Good morning. Are you Christopher Falk?
Yes, ma'am.
And this is cause number 241891. Mr. Falk is charged with assault on a public servant. There was a request to have Mr. Falk examined for competency to stand trial. Dr. Grapon did that evaluation. I've received that report dated May 30th of 2025. It has the finding that Mr. Falk is currently competent to stand trial. Is there any other evidence with regard to competency?
Nothing.
No, Your Honor.
All right, then based on that, I am going to find at this time Mr. Falk competent to stand trial. And do you need some time for an announcement, or are y'all ready to make an announcement today?
A little more time, Judge. I have talked to him a little bit since we've gotten the report back, but I think we need to talk to state a little more and see if we can get it worked out.
All right, I'll reset that one more time, and then we'll see if we can get an announcement at the next court day. Is that your computer? That's okay.
Do I need to get the bailiff?
All right, we'll reset it. We'll get an announcement at the next court date. You can go back with the bailiff. And then you've got David Tillman, 2 cases.
And Judge, Kevin Train, he's be coming up. This is one that me and I'm looking to talk about. I think we need to get him evaluated. And actually, one of the bailiffs let me know they've had an issue with him this morning. So
Let's go ahead and also reset Mr. Tran. We'll have an evaluation done on him if y'all wanted to get that order that we have for that to be done. I'm thinking about something else. All right, sir, are you David Tillman?
Yes, ma'am.
And, all right, so it looks like there is we've got cause number 22-40540 and 24-0536. And will your client waive the formal reading of the motion and the indictment?
yes, ma'am.
Okay. Just a second to get there. Okay, Mr. Tillman, in cause number 240536, are we going on count 1 only?
Yeah, sure.
Yes, sure.
God bless you. The state has elected to proceed on count 1 only. It alleges you committed the first-degree felony offense of aggravated sexual assault of a child from August 15th of 2022. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yeah. Yes.
And are you pleading guilty because you actually did what they charged you with?
Yeah.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Also in this case, do you understand that you will be required to register as a sex offender? It looks like you've signed that paperwork, and have you gone over that with Mr. Lewis as well?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Tillman is not competent?
No, Judge.
All right, Mr. Tillman, in cause number 240536, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. find sufficient evidence to find you guilty, and at this time find you guilty of aggravated sexual assault of a child, sentence you in accordance with your agreement to a term of 20 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Okay, and then,
And it's a little confusing, Your Honor. The motion does not contain that the offense he just pled guilty to because the dates, the new offense predates him
Gotcha.
being put on probation, so it's not
Okay.
part of the revocation.
gotcha, thank you. All right, and then in cause number 2240540, I have a motion to revoke your community supervision. Shows that you were placed on probation May 1st of 2023 for the offense of unlawful possession of a firearm by a felon, and that was a 10-year term in prison that was probated for 6 years. Is that correct?
Yes, ma'am, that's true.
And it alleges that you violated your probation. Count 1 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
That's true.
Count 2 alleges that you failed to provide verification of entering and successfully completing the MRT, the Moral Recognition Therapy Program. Is that true or not true?
That's true.
And then count 3 alleges that you are behind in your court-assessed fees. And is that true or not true?
That's true.
Did you enter your pleas of true to each of those counts freely and voluntarily?
Yes, ma'am.
And did you plead true because those counts are actually true?
Yeah, true.
I also have some documents here on the computer in that case that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Lewis?
Yes, ma'am.
And do you fully understand them as well?
Yes.
And do you understand, again, if I follow the agreement in this case, you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. All right, Mr. Tillman, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Sentence you to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. I'm handing you now, in each of your cases, the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. We already went over that when I put you on that probation. I just want to make sure you understand, based on the judgments in both of these cases, you are ineligible under Texas law to possess a firearm or ammunition. If you have any questions about that, make sure you read that document and talk to Mr. Lewis.
Yes, ma'am.
All right, good luck to you, sir. You can go back with the bailiff.
I have one question.
Yes, sir.
Does the time I get credit also include the time I was in Oklahoma?
So the time that you will get credit on is any time that you were either in our custody or that we had a hold on you. So if we had a hold on you from Jefferson County and you were in some other place being held, then yes, you would get that. If we did not have a hold on you, then you would not.
All right.
Okay?
Thank you.
Yes, sir. Good morning, ma'am. Are you Michelle LaChasse? And this is cause number 2239304. Ms. LaChasse is on probation for abandoning or endangering a child. It's a state jail felony. And that probation was for a 3-year deferred probation, October 17th of 2022. Has that been extended? Okay. So obviously, we'll see what we do today, but if there's going to be safety, I think that would be a requirement for me to do that. So I received an administrative hearing on April 30th from Mr. Ruiz with some issues that have been going on with regard to Ms. LaChasse allegedly going to the Sky Bar Lounge, failing to adhere to the curfew, failing to adhere to mental health services and treatment plans, remaining compliant with medication. admitting to drinking and also admitting to trying to locate drugs as well. That hearing recommendation was to continue supervision and request safe P, which was agreed at the time by Ms. LaChasse. I signed off on that and ordered it. Mr. Nix has filed a motion asking that I reconsider that. I have asked probation for kind of an update in their response to that, as well as the state, who said pretty much it's up to me and probation and everything else. So it's my understanding, Mr. Nix, that Ms. LaChasse is wanting to do some kind of local inpatient treatment.
So, Your Honor, if I could briefly just kind of give a little bit of a recap. She had her medication switched on March 11th and March the 20th. And shortly after that, if I can present this, I've shown a copy to the district attorney's office this morning. It showed that they made a major medication change, took her off Seroquel, put her on Prozac. She immediately started having issues with the Prozac. She's still having issues with the Prozac. She's taking the Prozac at the jail. They're giving it to her. She's having issues. What we've done is we've spoke to Baptist hospitals. I have her mother and I have her fiance here. We have documentation that she would be accepted into inpatient at Baptist Hospital. Also have a letter from her doctor.
But that's just a 5 to 7 days.
No, they can actually keep her inpatient for up to 30 days, Judge, and then they have an outpatient program that could continue after that. If I could present this is a letter from her doctor that kind of underlines her very exacerbated issues. What I'm asking the court to do is not to exactly undo the safe P. What I'm asking the court to do is hold the safe P in abeyance, give her a chance to do the inpatient Baptist, make sure that she's on the right medication. I presume that a major medication change is about to take place due to the fact that she's having such issues with the Prozac, and we reconvene after she's completed an inpatient stay. Whether it be 14 days, whether it be 30 days, I'm assuming it'll be 30 days based on what the fiance's talked to with Baptist. It would come at no cost to the taxpayer or to probation. We've already cleared it with her insurance. She's stayed there before, and insurance covered almost 100%. I'm asking the court to just hold the safe P in abeyance until she can do the inpatient treatment. We reconvene in 30 days and see how she did in the inpatient treatment. And then depending on how the reports go, how everything that I turn over from her inpatient stay to both probation, the state, and the court, you decide if safe P is still in her actual best interest at this point. We understand that safe P is also a blessing. She could have been sentenced to state jail time. We're not underscoring the issues. We're explaining to the court that this is a mental health issue caused by a major medication change that's documented. Her issues follow immediately after this. And she's still on the Prozac, and she's still having lots of problems in the jail on the Prozac. We're asking that we just hold this in abeyance. I'm not asking the court to undo it, take it away, put her back on regular probation. I'm not asking for that. I'm asking to hold it in abeyance, place her, allow her to be placed in the inpatient.
But do we know, is it up to the hospital how long she stays?
I believe so,
I
Your
can't
Honor.
order some
Correct.
certain amount of
Correct.
time.
And however long that is, if the court feels that it's not long enough, we can reconvene and I can show you the records at that point and we can make a decision from there. But Baptist has told the family that it would be up to 30 days and then they have an outpatient treatment that can continue after that. Now, of course, we won't know if that's appropriate until we see how she does in there, but it's pretty clear that this is a medication change that caused this behavior.
Mr. Nichols?
Judge, the main hesitation on our part is that she agreed to safe P and now wants to do things on her terms. I think safety is where she needs to be based on the relapse and the violations she had. And I want to bring the court's attention, when she was first put on probation in 2022, she was ordered ISF. Didn't want to go, went to a private inpatient program in Harris County, which she was discharged unsuccessfully from. So it's almost like we're rewinding the same script as before, and it obviously didn't work then.
I didn't see that.
I don't think it's contained in the admin. I think Mr. Ruiz can testify to that, though, Your Honor, if you want more detail. He informed me about that this morning.
Okay. Do you have any disagreement with regard to what happened at the beginning of probation that they're talking about, Mr. Nix?
I'm not sure that I was a part
You were a
of that, so I don't know that I can speak to that. What I can speak to is that they made a major medication change that immediately caused these issues. SafeP is a wonderful program that's helped a lot of people. I don't know that it's fine-tuned for her mental health issues that are causing the issues right now. I think it's a fantastic program, and I still think she might end up there, but I think if we get her the right mental health treatment and get her on the right medication, she's much more likely to be successful in SafeP if she has the right medication and she is of the right frame of mind.
The special needs SafeP facility, do they adjust medications and things like that? Yeah. I think based on what I know now from the beginning that I ordered or agreed or whatever happened with ISF and then agreed to allow her not to do what everybody else thought was appropriate, go to her own choice, and successfully discharged from that, and here we are having the same problem. So I'm not going to adjust that order.
Yes, ma'am.
I am going to order the special needs. It's special needs safety. It's not the regular one. It is, the whole purpose of it is to treat both things. And so that can all take place there, and I think that would be better for her and for our community. In addition, I am going to, because of the issues in the administrative hearing, the fact that a motion hasn't been filed, the length of time, I think, obviously is an issue. And so I am going to also at this time order that Ms. LaChasse's probation be extended by 2 years. That should give plenty of time to get through the program, get through aftercare, make sure everything is going like it should be, and then hopefully get off this probation without a conviction or going to state jail. All right, I know it's not what you want. I hope you take advantage of it. However, it's a good program. You can talk to them about medications and get stabilized before you get out and get on aftercare. Okay, thank you, Mr.
Thank
Nix.
you, Judge.
Thank you, Mr. Ruiz, for being here as well. That he's pleading on it. I need,
Got these right here. If that's what you need.
everything, all of them except 0534. Good morning. Are you Bryce Thomas? And Mr. Burbank, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor. We're going open on each case, and the aggravated sexual assault is being the lesser included indecency by exposure, which is a third.
So is,
Did you sign it? Did not.
we can do it, y'all can get it done as soon as I'm finished. I'll go
Completely about the registration.
I'll go through it with them. I just want to make sure, because of the agreement for the lesser in that case and for anything to run concurrently, is that the plea bargain agreement where he would be waiving his right to appeal?
And also they're
dismissal.
dismissing the UUMB.
Gotcha, okay. Give me just a second, yeah.
And the lesser included is instead of a first is a
Third. Oh, 0354 is being dismissed, I think. Or 0534, whatever I said. Okay, Mr. Thomas, in cause number 24, DCCR 0389, you're charged with a third-degree felony offense of possession of a prohibited weapon from January 31st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In cause number 24-0390, you're charged with a third-degree felony offense of possession of a prohibited weapon from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In cause number 24 DCCR 0391, you're charged with a state jail felony offense of theft of a firearm. And that's from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? And then what is the reduction to?
It's indecency exposure, third degree felony.
In cause number 24, DCCR 0392, the state has elected to proceed on the lesser included offense of a third-degree felony of indecency with a child by exposure. And that's from November 9th of 2023. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them? And I want to make sure you understand there's kind of a partial agreement, and that agreement is that the state is going to dismiss cause number 240534, which is an unauthorized use of a vehicle. They are agreeing to that lesser included offense of the indecency in that case. And they're also agreeing that if anything that I sentence you to, if it's time in prison, would run concurrently. There's not a specific agreement with regard to any time or any outcome, only those agreements with regard to the dismissal of the case, the reduction in the other case, and the fact that they'll all run at the same time. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, in that indecency case, do you understand that you will be required to register as a sex offender? And Mr. Burbank will go over that more with you today, and there's a document you need to sign today with regard to that. And do you understand that as well? State tenders number 1 in each case.
No objection, states 1 in each case, Your Honor.
It's admitted in each case. Is there any evidence that Mr. Thomas is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each of your cases to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done. That'll give me more information about you, your cases, and we'll come back later for sentencing. Anything that you think is important for me to know is on probation for driving while intoxicated, third or more. A motion to revoke has been filed, and Mr. Cole has filed a motion asking that I set a bond in this case.
Yes, sir.
And it looks like the allegations from that motion are that Mr. Idlebird, while on probation, allegedly committed the new offense of driving while intoxicated, third or more, January 9th of 2025 in Chambers County, Texas, that he left Jefferson County without permission, that he drove a vehicle that did not have an interlock device on it, that when he was stopped, the allegation is the intoxilizer that was administered provided breath samples of 0.108 and 0.115 and behind in his fees a little bit as well. Mr. Cole?
Well, Your Honor, I think since the time that Mr. Otterberg was put on probation in 2017, up until this latest incident, his mental capacity has changed dramatically. He's been diagnosed with Alzheimer's. He's on the verge of his nerves inside of his brain have shrunk. So on top of the Alzheimer's, he's has the possibility of having a stroke. So I think that this is him not remembering the conditions, and his wife is here that can, his keys, you're taking his keys. We do have paperwork that I gave to counsel that can, from the doctor showing that he does have Alzheimer's. He was diagnosed in March with Alzheimer's, and the nerves in his brain are shrinking. Your Honor, he's unaware that he even violated the condition.
Well, that makes it even scarier for me.
That I know it does, but we're asking that we get him out, and his wife is going to take care of him and make sure that he doesn't drive that car anymore. Take the keys. Now that we're aware of.
Why don't you, if you want to put on a witness, that might help.
I'd like to call Gwendolyn Brown, please.
Okay, Ms. Brown, come on up, ma'am. Do you have some documentation about Good morning, ma'am. And your name, what was your first name?
Gwendolyn,
Gwendolyn Brown. And Ms. Brown, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
yes, ma'am.
Thank you. Go ahead, Mr. Cole.
State your name for the record, ma'am.
Gwendolyn and Albert.
Yes, ma'am. And how long have you known this gentleman right here?
But we've been married 13 years.
13 years. And when did you start noticing deterioration in his mental capacity?
Back in December last month. Last year, 2004.
And I guess another question I want to ask you is,
Can you speak up, please?
what are you willing to do to ensure that Mr. Heidelberg no longer has access to the vehicle?
I will take the keys from him. He will not drive anymore. Nothing.
He already had it.
I already had the keys. He can't drive anymore. He will not drive anymore.
That's her car. That's her car.
Oh, I'm sorry.
Oh,
He will not drive anymore. I will take the keys from him, and he will not drive.
And do you think that in this situation that happened in Chambers County, do you think that he was aware of the conditions of probation that he was violating?
No, he wasn't aware because his probation officer told him that she was done with him. So when you say you're done with somebody, that means you're done with them. You thought he wasn't on probation anymore.
So there's a lot going on upstairs, Your Honor. I don't want him showing back up in a red suit. I know she can care for him outside of this facility that he's currently in right now, which is in jail. We have a court case in Chambers County that we would like to be at. And I don't think that he was intentionally violating probation. I think that he, at this point, his mind is...
He get lost all the time.
Yes. So he's getting lost. He doesn't know whether he's coming or going. And I can have a conversation with him right now, and he'll forget it in the next 2 hours. So, it's one of the
Thank you, ma'am. You can have a seat.
I just want to say one more thing.
Yes, ma'am.
When he was in jail in Chambers County, the probation officer told me to bring him to her as soon as I get him out of jail, right? So I brought him to her, and then she called his name, and I was going upstairs with him, and she said, "Miss Oliver, you have to stay downstairs." So she went, she said, "Only me and my supervisor need to talk to him." So the supervisor talked to him, and when he came back outside, I said, "What did she say?" He said, "Nothing." She said, "Go home." But she had told him to go turn himself in to Jefferson County. He
Okay,
didn't remember by the time he got back to the car.
okay,
So he would have been in jail.
right. Thank you, ma'am. Ms. Malfino, based on,
Obviously, I have the same concerns as the court based on the representation of his wife, that he won't be driving. That gives me a little bit of comfort. I did speak myself with Ms. Hunter. I know she's probably just told him what the rules are, and maybe he doesn't understand them, but I know she hasn't been combative with him. She initially told me she doesn't oppose him being a bond. I don't know if she's aware of these medical conditions, but again, our concern would be the driving factor. And obviously you couldn't go somewhere like mental health safety or anything with that.
No, not with that diagnosis, and I don't think with that diagnosis either.
Okay.
Let me look at something else. All right, so what I'm going to do in this case is set a bond. I'm going to set the bond at $5,000. I'm going to order that a condition of that bond is that Mr. Idlebird not drive ever. And I'm doing that on the representation that the keys will be taken away, hidden, whatever's necessary. And so I'm looking at you, ma'am, that you are giving me that representation to make me feel comfortable that he doesn't get the keys somehow and drive. So just sticking them in your purse or sticking them in a drawer with this type of diagnosis is not going to be good enough. I'm going with your assurances that you're going to take care of that. Obviously, you don't want anything to happen to anyone else in the community as much as I don't. So I'm going to do this based on the fact that you're giving me those assurances. And then obviously there will not need.
Every decision you witness today will stay with these defendants long after they leave the courtroom. Some walked away with hope, others with years behind bars. But every ruling carried real consequences. The biggest question is, did justice truly prevail today, or would you have made a different decision? Tell us your thoughts in the comments below. And if you're fascinated by real courtroom drama, shocking verdicts, and powerful legal stories, don't forget to like, subscribe, and turn on notifications, because the next case could be even more unbelievable than this one.